Hello everyone, welcome to this webinar from FTB on remote hearings for SEN appeals. I'm just going to wait a few additional seconds just to allow people to arrive in the room, and then we'll get started. Right, I think we'll get underway. And to repeat for those who've just joined, you're in an FTB webinar on remote hearings for SEN appeals. Thank you very much for joining me today. Unfortunately, you will not have the benefit of Michael Brett's wisdom, and we're very sorry for that. Michael is in a hearing today, which was supposed to finish at lunchtime, but these things sometimes happen. The hearing went over the lunch adjournment, and this unfortunately has prevented him from joining us today. So I'm going to do my best to deliver Michael's slides as well as my own. I'm going to start by sharing my screen so that then we can get underway. So hopefully you can see my screen now where I've got the PowerPoint slides. And before I begin, let me just say a couple of things by way of introduction. So firstly, all the slides that you see today, we can circulate afterwards. So don't worry about trying to studiously take notes. You can get the slides afterwards. We'll also put a recording of this webinar on our channel online, and we'll send you the link to that so that you can have a look at it. And for that reason, obviously watch the questions that you put in the chat box and be aware that, that those will appear on the recording. Secondly, can I encourage you all, if you haven't already, to sign up to the FTB mailing list, as FTB is really now in the practice of conducting remote webinars. This is the world that we live in these days. And we've come up with what we hope is a really useful package of webinars to help our clients. There's going to be a break for the summer months before we restart again in the autumn with more webinars. So please do sign up so that you're given notice of all of those. Now, how I propose to proceed today is really in quite an informal way, especially since that's only myself appearing and we don't have Michael. The purpose of this webinar is for me to share some of my experiences in the SEN tribunal over remote hearings. I think I've now done perhaps 10 or 11 of these remote hearings over the last few months, and I hope I've got some useful insights to share. But equally, I would be very interested to hear your insights. And you should see in the software a facility to ask questions. And don't think you need to limit yourself to questions. Please raise comments, challenge what I say if you think I've got it wrong. Tell me about things that I don't know. It would be great if we could have a discussion in this webinar, to the extent that you can really facilitate a discussion where only I can talk. But I can certainly see your messages. I'll do my best to keep an eye on the Q&A box throughout, so that if there are questions that come up, I deal with them as we go. So without further ado, let's get started with the presentation. And the first part is really Michael's bit, and it's covering the real basics, teaching you how to suck eggs as to the procedure for these remote hearings. Apologies if you know this and you've done many remote hearings yourself, but I thought it would be useful just to cover the basics before, in the second part, I turn to my advice on top tips. So, firstly, it's important to recognise that virtual hearings have been a feature of the judicial system for some time. This isn't entirely novel, the adaptations that have been made to facilitate remote hearings. So we see in the rules for the first tier tribunal that there's already provision for remote hearings within them. So the definition of hearing includes expressly remote hearings. The overriding objective and the delivery of that by the tribunal includes many elements that facilitate the conduct of remote hearings. So there's an emphasis on achieving flexibility in the conduct of hearings and proceedings, of avoiding delay, for example, and that, of course, can be conducive to remote hearings. In terms of case management powers, you see reference in 5.3G to the judge having control of the form of the hearing. And so the implication there was that the judge could decide upon remote hearings as the appropriate form for a hearing to take place. So this is not something that is completely novel within the procedure of the FTT. The software that Her Majesty's courts and tribunals use for remote hearings throughout the judicial system is what's called Cloud Video Platform. And this is a system that's, that has been or is being rolled out across the judicial system. Now, although the software, as I understand it anyway, is the same, it seems to me, and I do a number of areas of law, and I cover a number of areas of law in my practice, it seems to me that the approach that courts are taking as to how the software is used, and indeed the level of uptake of the software, is not uniform at all across courts and tribunals. And those of you here who do only special educational law should thank your lucky stars that that's all you do, because practitioners who engage in other areas, criminal law being the best example, are struggling with a judicial system that really hasn't adapted very quickly to picking up remote hearings. Whereas I think the SEN tribunal, people do challenge me if you think this is an overly positive comment, but I think the SEN tribunal has in fact adapted pretty well to this new reality. In terms of how you access the software, primarily it's through a browser, and the recommended software is Google Chrome. What happens is the tribunal administrators are sending, several days prior to hearings, a notification of hearing, which will have a hyperlink, and you click on that with your browser, and that allows you to access a similar setup to what you're using now with Zoom. Now, it is possible to access the video hearing only through audio by phoning the relevant telephone number. And indeed, it's possible to do the two. And I've adopted that hybrid approach a number of times when I've found that the quality of my internet connection is good enough that I can sometimes simultaneously speak, see, and hear what's going on through my internet browser, but I'm aware that it's sometimes a bit jumpy. And so, because I want to ensure that I've got constant feed of what's going on, I have actually on occasion had the software on the browser whilst also having called the relevant unique telephone number. on my phone, so that I can just ensure that if the internet does block out, then I've got the audio as a backstop. You don't need to purchase any software to access the hearings. The software is inbuilt, and you access it through your internet browser. In terms of just really key back to basics things, but nonetheless very important, when it comes to preparation, do ensure that your computer is up to the task as to conducting a remote hearing. Probably if your computer is a couple of decades old, might be worth thinking about borrowing or buying a new one. And very important is a good internet connection. This is something that you can test through tools that you can obtain online. I think good internet connection for our profession has now become, and indeed lots of other professions, has now become absolutely key. And I've spent countless minutes, including hours, on the phone with Virgin Media, my internet service provider, all focused on trying to make sure I've got decent internet so that I can take part in hearings properly. Focus on thinking about where you're going to be in the hearing, and if you're in a household where there's going to be other people around at the time of the hearing, do your best to talk to them, ask them very politely not to interrupt you. Of course, when it comes to children, there's only so much that you can do, and the tribunal will be very understanding if children interrupt, and indeed if you need to take breaks in order to take care of childcaring matters. Now, there's no facility, as there is with Zoom, to adopt a virtual background. So do try to clear your room of things that might distract or things that might embarrass, which is what I've tried to do here. I've tried to make this a room where I'm not going to distract the court or the tribunal when I take part in hearings. Now, there's no facility for practicing participating in hearings or practicing the tech. The tribunal haven't facilitated that, nor am I aware of any courts that have come up with a sort of practice model. And so, in terms of all the logistics and the guidance, that's something that you and your team are going to need to give thought to in advance of the hearing. And if you think it's a good idea, conduct your own practice session, just in order to make people comfortable with what is a very new and different way of participating in hearings. Don't be like this gentleman. I hope all of this image will conjure smiles on your faces as to the horror that he felt when his adorable child came into the room. Try as best as you can to not be that individual, and to have sort of pre-warned all of your children to not interrupt. In terms of the joining details, as I say, the code and the link, that's going to be circulated in advance of the hearing. Note that the particular link that you use to access the tribunal is unique to the hearing in question. So don't mix them up and don't click on an old link. And do make sure that everyone on your team knows all the basics, they have the joining details, and they're all ready to go. As Michael's emphasised in that final bullet, note that there isn't a help desk that you can call to ask questions about the technical issues or the logistics. There isn't that. There is some guidance, but really it's just over to you and your team think everything through and be as prepared as possible. What happens on the day is that you will be asked in the notification of hearing to join the software approximately 30 minutes before the hearing is listed. So it will usually be 9:30 in the morning or 1:30 in the afternoon. And the purpose of joining early is so that an administrative member of the tribunal staff can ensure that your connection's okay, that you're hearing everything, and of course make sure you've logged into the correct tribunal hearing. You'll then, after you go through the motions with that member of staff, be asked to log out and then log back in. In the hearing proper, when it starts, the judge will speak first, ask the panel to introduce themselves, and then ask everyone else to introduce themselves, and then usually the judge will decide how the rest of the hearing is going to progress, although sometimes the order in which issues are dealt with is something that might be debated at the start. And indeed, I'm going to say a little bit more about that later when it comes to my top tips. During the hearing, the procedure is going to roughly proceed in the normal way, and you'll recall the flexible way in which the tribunal conducts itself and its hearings. It's not the same level of formality as appearing in the High Court or any of the criminal courts. And so the tribunal will continue to really exercise a great degree of flexibility when conducting the hearing. Very important, and something which everyone continues to, on occasion, forget, and that includes myself, is to mute yourself unless you're speaking. Now, this is important for a couple of reasons. One is that even very limited background noise, which is picked up by the microphone, can be very distracting for everyone. So even if you aren't speaking, very small background noise, typing, clicking the mouse, chirping of a bird outside can be over-exaggerated on the call and can cause distraction. The second thing is that, like most similar platforms, when someone's microphone picks up noise, the video screen on all the participants' laptops will pick up that person's screen. And so the video will change from the individual who's supposed to be speaking and swap to you, and that will be very distracting, and it will frustrate everyone. So please do mute yourself. It's much more important that you mute yourself when you're not speaking, and therefore prevent interruptions of others, than the risk that you are muted when you want to speak. Because if you're muted when you want to speak, people will note that you are moving your mouth and not speaking, and they'll no doubt quickly point out that your microphone is off and asking you to mute. So that's a really good tip. When there are breaks in the hearing, disconnect and then just resume at the appropriate time. You're going to need to give careful thought to who needs to attend the hearing, and clearly, if there's a representative, they've got to attend. Witnesses. What might be more difficult is thinking about the role of translators and supporters for the appellants in SEN hearings. I'm going to talk about translators more just in a moment. So I'll turn to that in a second. And, top tips: inform the tribunal, that should say, about who's attending, so that they know and your opponents know. And also make sure that that everyone really knows the details as to who's connecting. And Michael's put some guidance on there. So turning to translation of sign language. So I've been involved, I think, in a couple of cases where the child in question has used the medium of BSL, British Sign Language signing, in part or in whole, in order to communicate. And in those cases, the tribunal had arranged for an interpreter to be present. Now, I have not yet encountered such a case in a remote hearing context, and I imagine if I did, it would be, really expose some very challenging issues. It seems to me that, from what I've learned from those cases I did involving BSL, that it's very, very difficult in a remote hearing context for an interpreter of sign to properly understand and translate a signer, and so this is going to have to be tackled somehow. And I think the issues are that, I suppose, firstly, the signer will need to have constant video surveillance of the interpreter. The interpreter and the signer, they need to see each other constantly. And that's not something that is easily provided for within the format of the video software that the tribunal uses, because the video image will pan to whoever's making noise. So that's one difficult issue. And I suppose a separate form of video feed would have to be set up in order to enable that. And that, as I say, will be really tricky. Also, moving beyond signing as a problem in this context, I imagine that there will be children, young people, and indeed their parents who might find appearing on video very uncomfortable and disorientating. And that might be because they see their own image, or because they perceive by looking at the screen that there are a great many people who are scrutinizing them. And so if you are acting for the appellants, I suggest give that thought, deal with it very sensitively, and do your best to assuage the concerns that are raised by a vulnerable person in that situation, and indeed make the tribunal aware if it's appropriate to do so. Right, so that's the basics, if I can call it that way, the sort of nuts and bolts as to accessing the hearing. What I now want to do is cover what originally was only my only part of the presentation, which are my top tips, in my experience, for giving you the best chance of success. No questions asked yet, so that might mean that I'm covering all the basics, or perhaps I bored you with the basics because you know all of this stuff. I hope if that is the case, then the next part will be of more interest as we're getting into realms of strategy here. Firstly, absolutely essential in my view to set up a means of simultaneous private communication with your team. And for that purpose, I use WhatsApp, and I haven't yet heard of a better alternative to that. So I commend WhatsApp to you. Now, you can use this as an advocate or as a client or witness to receive or send instructions to the advocate in a way that's private. You can discuss matters of approach and strategy. You can discuss issues and who's going to deal with them. And that is not something you can do easily or conveniently unless you have WhatsApp or a similar facility in use, because the software that the tribunal uses for its remote hearings simply doesn't allow this. So what you are presented with when you join the hearing is a facility whereby every participant can see you and hear you, and you can talk to every participant. You can also, in a chat box, communicate with every participant. There isn't, however, a breakout room function or a private communication function that you find with Microsoft Teams, Zoom, Skype, etc. You don't have that. And so you need to set that up. It's the equivalent of having the ability in tribunal to hand a sticky note to a member of your team asking a question, or the ability to ask for an adjournment from the judge and to step outside so you can talk to your team. Here, you can't connect with your team privately and confidentially unless you set that up. So absolutely key. It's my number one top tip. Note that another few advantages of WhatsApp. Promise you, I'm not getting any commission from this Silicon Valley company. This isn't just a plug for them from commercial reasons. But other top benefits are that there is encryption with WhatsApp. So there's a level of security there, although I would respectfully suggest that you don't put in any personal information for GDPR reasons, and there's no real need to do so. That's a benefit though, the level of encryption. Secondly, you can actually get WhatsApp on your computer, which helps because on your phone, it's a much slower piece of hardware, your phone, in order to send messages. Whereas if you downloaded the WhatsApp Apple or Microsoft software, you can use your keyboard in order to send messages. And that's a very quick way of messaging one another. And also, it's also important just to frankly have a means of breaking the tension, which you would have in a real hearing. You'd have a level of informality with your own team that you can only really achieve if you set up some sort of communication like this. And without this form of communication, it's only communication on a very professional front facing the tribunal. One other point on WhatsApp, a really important one is, let's say there is an adjournment, the tribunal has asked you to take instructions on an important matter or to clarify your position. With WhatsApp, you can just, if you've created a group that contains all your team, and you might have a large team in some of these cases if you've got multiple therapists involved and multiple members of your team, you're able to, in your group, just with a click of a button, just click group call, and then everyone within a few seconds can join a call. And it really does just benefit the speed of the delivery of your case if you're able to talk with your team privately in such a quick and effective manner. So that's WhatsApp. Top tip number one. Top tip number two is preparation, preparation, preparation. Absolutely key, especially in the context of remote hearings. Run through the format of the hearing with your team. Run through the technical issues. Run through who is going to say what they're going to cover, what the key issues are. Deal with all of the issues of preparation. Make sure the WhatsApp group's created. Everyone's joined it. Everyone's got the papers. This isn't like in physical hearings where when you're at the court, if someone has forgotten part of the bundle, they can share from the bundle that others have brought. You're really left standing only on your own 2 feet in these cases. And you need to make sure then that every single participant in the hearing has everything that they need. Look through and think through the technical and logistical issues. Make sure that your team, they've all got good internet, that they've thought through how they're going to have access to the papers whilst also delivering on screen. Identify the key issues in dispute. Now, it sounds like such an obvious thing that it's not worth mentioning, but from my experience, I do need to emphasize this because I've been in so many SEN hearings where, for example, a therapist is there, an occupational therapist, speech and language therapist, or a psychologist is there, and they're asked to comment on a very specific issue, which is usually about provision. And instead of answering that key issue in dispute, they traipse off a whole load of information which isn't helpful, not to the client, not to the tribunal, and it distracts and it wastes time. So do identify the key issues in dispute to make sure that your team are absolutely focused on the key points in the tribunal, and that will give you the best chance of success. Now, in terms of brevity and focus, I'm going to come back to that in a moment and emphasize why I think that's even more important than in in-person hearing. But for the purposes of preparing your team, I suggest that that's something that is emphasized. Emphasize to your team that they should deliver their points in the briefest possible way and really focus on the key issues. So that's preparing your team. Next, agree as much as possible. When you're in a hearing, an in-person hearing or remote hearing, you will tend to be the two individuals in the image. You're there in an adversarial capacity. You're there wanting to deliver the more persuasive argument and wanting to outshine your opponent. And that is, of course, a necessary format of proceeding when it comes to issues where the parties are diametrically opposed and where there's not going to be any movement. However, if there can be movement on issues, then it is of course for obvious reasons a good idea to try and to reach agreement on those as much as possible. That will allow you to focus on the key issues. It means that your case will appear more credible and more considered, because you are not causing the tribunal to waste its time on issues where there's no real dispute. It can see that you've reserved the tribunal's very valuable time for only the core issues in dispute. Now, the reason why I emphasize this is my second bullet, is that in physical hearings, you would have naturally had an opportunity to reach agreement, because prior to the hearing, you and your team and your opponent's team will have likely congregated around the entrance to the court, and would do so at every adjournment as well. And so you would naturally have that opportunity to discuss things, discuss matters that can be agreed, try to agree what the issues in dispute are, clarify each other's position. But now there isn't that opportunity. Unless you proactively set it up, you are not going to have an opportunity to discuss with your opponent all of these things. My third bullet, just emphasizing that there's no breakout room facility in the software. So the judge can't say, I'm now going to place you, Mr. Waller, and your opponent into a breakout room so that you can try and agree these matters. They can't do that. And so in terms of facilitating agreements, it's something you've got to set up. And what I suggest is give thought to a conference call in advance of the hearing, and set that up. Or what you might indeed like to do is ask the tribunal for a brief adjournment on the day in order to discuss things with your opponent to make progress. And in my experience, I've done it a couple of times now, where I've thought that there are issues X, Y, Z that frankly my client and the opponent will move on, where it would just save a lot of time if I got everyone together in some sort of conference call and just sort of fleshed them out. And it's been very successful in the two occasions when I've attempted it. My penultimate bullet: think about whether you want your witnesses and your clients to attend that call. In my experience, it's a good thing. Whereas in physical hearings, in-person hearings previously, often my approach was that I would step aside with my opponent and try to reach agreement, and then go back, get instructions, and then sort of ferry between my clients and my opponent. And that works well in an in-person environment. This remote environment which we find ourselves doesn't as easily lend itself to that approach, however, just because you can have lost momentum if you're calling your opponent and then needing to hang up, calling your client, hang up, and a circle like that. And so on the two times I've done this, I've actually asked for my team to all be on the call so that it's sort of in a round table way, these issues could be fleshed out. My final bullet is a bit of creative thinking, which I picked up on from a judge actually. A judge in a SEN hearing I had a few weeks ago suggested that what they would do is the panel would turn off their video, microphone and speakers so that the parties could discuss matters and try and agree matters. And the benefit of that approach was that it really just saved time. It meant that the parties could use the software that the court sets, that the tribunal sets up, in order to facilitate this conversation. The alternative would have been that all the parties would have had to have separately agreed some sort of teleconference number or a Zoom link in order to speak. So that I thought was a brilliant idea from that judge. That was implemented in that hearing to great success. I then stole the idea and suggested it in a hearing I had last week. And again, it bore fruit. And within sort of half an hour, a list of, say, 10 issues in terms of the contents of this child's plan, that list of 10 issues had gone down to about 5 issues, because I was able, with my opponent, just to reach agreement on matters where, in reality, there wasn't a big difference. It was matters of semantics, matters of duplication in the plan, things like that. So that's that top tip. Agree as much as possible and take steps to try and achieve that. Next, how to handle the written evidence. And here, it's incredibly important. It's more important than in physical hearings for all of the written evidence to be paginated. And that includes late evidence. Now, the importance of this flows from a number of quite obvious points, really. The panel probably will not have hard copies. My experience has been in all the SEN hearings that I've done remotely, that the panel is working off of their laptop where they've got the papers. And that approach makes it more difficult to handle multiple documents than would be the case in a physical hearing. In a physical hearing, the tribunal can make sure that they have physical copies of everything. They've got it in front of them. They can mark them up. They can work on them. If a advocate wants to refer to a piece of late evidence, even if it's not paginated, it will usually be quite an easy exercise for the tribunal judge to figure out, well, what's being referred to here, because they can just hold it up and they can say, you know, what are you referring to? Is it this page here? And then the advocate can confirm. That's not so easy in the context of a remote hearing. In a remote hearing, if there is a large amount of documentation, and in my experience there invariably is in these cases, then it's really important to paginate everything and to be aware of how many electronic files the judge and the expert member or members needs to access everything. So you want to know that there are, say, 3 PDFs. There's the main bundle, there's the supplementary bundle, and then there's a third PDF containing late evidence. And just be aware of that and give thought to that. My second point is that in an ideal world, you want to see at all times the video hearing, the evidence, your note, and also the working document. Now, in order to achieve that on one screen, it's very, very difficult, impossible probably, unless you've got sort of one of these enormous Apple desktops that takes up a whole desk. What I do actually is I have 2 screens in order to achieve this, and it's really it's a real benefit, because it means that I don't waste any time at all when I am in the hearing. And if a judge asks me, for example, for a reference, I am able to accept that message from an instruction from the judge, and I can just turn and I can very quickly find the reference, as I could in a physical hearing, because I would have the judge in front of me and I'd have my bundle of papers next to me. What you don't want to do is be in a position where you're changing tabs on your computer and you're swapping between the screen where you see the judge and your notes and other papers, because doing so is liable to cause confusion. It's going to be very tiring for you as well, and that's not good for your ultimate prospect of success. What I do, this is my last numbered bullet. What I do is I have a printed note which records all the key page references so that I've got them to hand immediately for when I need them. And that will have the key report. So if it's a contents appeal and there are issues regarding diagnosis or provision, then I've got all the key references for the SALT reports, the OT reports, the EP reports. I've got that. I've also got a reference to the date, I've got a reference to who wrote it, whether it's their first report, second report, only report, whether that person was paid for by the local authority or the appellant. I've got all of that in one note. It's a really important tool to help you navigate the evidence, and also help others when others get they lose their place in the documents. So that's all absolutely key. Note also that in terms of page references, when you're in Adobe Acrobat for your PDF containing your bundle, the page shown in Adobe Acrobat, usually at the top of the screen, may be different from the pagination that's imprinted on the pages themselves, because usually you'll have the pagination starting after the index at the front of the bundle and not on the first page. So usually the Adobe Acrobat pagination is a little bit behind the pagination on the PDF. So just be mindful of that and address it in the hearing. Explain that when you give references, you're going to be referring to pagination of Adobe or the pagination in the bundle, and then be consistent in your approach and make sure your team is consistent in approach. Right, brevity and focus. Now, these are absolutely key, in my view, in the context of a remote hearing. And I'm going to emphasize some points why. And these flow from my experience over the last few months. The first thing is that somewhat surprisingly, from my perspective, remote hearings, I find, are actually much more tiring than the real thing. And I think the reason why is that you're having to, your mind is having to address additional issues than you have in person. You're having to think, right, is my microphone on while I'm speaking, or is it off while I'm not speaking? Is my laptop working correctly? Is my internet working correctly? Am I running out of battery? Is my child about to storm in, or my cat about to jump onto me? Things like this. And so actually, I found that participating in hearings is just much more draining than it is in person. The second thing is that the hearing will experience inevitably, no matter how much you prepare, although of course prepare as much as you can, it will inevitably face technical and logistical challenges, because there will be one person who constantly forgets to turn off their microphone. I've had that with opponents who will remain nameless over the last few months. It will be because somebody's internet goes down. It will be because there's a completely unavoidable case of a child interrupting, or something like that. And so you've got less time in the hearing, so you need to be brief and you need to be focused. Now, thirdly, and I would be really interested to hear if people agree with me on this, so please do say if you've got a view on this. Thirdly, my experience over the last few months is that the judge and the expert member has shown less of a tendency, or in many cases, absolutely no tendency whatsoever, to interrupt expert witnesses when they go off track. Whereas compare that with my experience of the in-person hearings that I would do in the tribunal, I recall the panel being very proactive in intervening when an expert witness goes off track, when they haven't answered the question, when they're giving too much information, or they're giving irrelevant information, and they're not showing that tendency nearly as much anymore. And my reflections on that are that the panel is more overwhelmed with the technical issues that they have to deal with, and at the need to navigate all of the tech, and the difficulties of making sure they understand the message from the person who's speaking. And so they're not assisting witnesses to remain on track. So it's really important then that everyone, advocates and witnesses, are considered brief and focused in what they are delivering, because otherwise I think there's a big risk that the tribunal will not really take in what you're saying, and that they will not help you to get back on track. So my experience, to really make this plain, is that on occasion where the tribunal wants to hear from a witness, or when I want to call one of my own witnesses, the judge will invite that person to speak, and then they will finish speaking, and possibly the judge or the expert member might have a follow-up question, but there will be no attempt, or very little attempt, to really hone in on the issues when a witness gets off track. So that, that's been in my experience, and so I'd really like to emphasize that point. Finally, this isn't really any different to in-person hearings, but the fourth point is that if you're brief and you're focused, there's more chance that your point is going to hit home, that the panel is going to find that a persuasive point, a credible point, and is going to tick that in your favour. You want to make it easy for them, and in a context where these cases involve an enormous amount of information, some of it very complex. So keep it very simple, to the point, and brief. And that, of course, requires great preparation, as I put. All of this, unfortunately, boils down to greater preparation and greater thought in these cases. Next, be proactive in your approach. Don't rely solely on the judge to handle the format of these hearings. That's my advice. And so, in particular, identify the key issues with your opponent and seek to agree things with your opponent. Don't expect the judge at the start of the hearing to say, right, I want you, Mr. Waller, you, Miss or Mr. So-and-so, to deal with issue 1, occupational therapy, issue 2, this, and all the rest of it. The judge might not do that, and that can mean that there's a missed opportunity there when the hearing could be more focused. So be proactive in really trying to identify the key issues. Try and agree them with your opponent, or do as I've done, which is use the opportunity right at the start of the hearing to get on the front foot by saying to the judge, Judge, there are 4 key issues in dispute in this case, 1, 2, 3, 4. And I would be surprised if the judge ignores your structure of the issues and how the hearing should proceed if you are proactive in that way. My experience has been that the tribunal responds very, very well indeed when you take that effort to help them format things. Third point, if you think that progress could be made, as I mentioned earlier, in conducting private negotiations, then ask for time to do that. Don't wait for the tribunal to start hearing live evidence on an issue that frankly is not important, or frankly is only really semantic in nature. And many, in my experience, many issues that on the face of it appear to be issues in dispute in terms of the stipulation of needs or provision in a plan are really in reality only semantic in nature. So don't wait for the tribunal to start exploring an issue in a great deal of depth and then become very frustrated when they realize that in reality there's not an issue here. And I'll give you an example of this. In a hearing several weeks ago for a client, had to ask the tribunal to deal with an issue that was simply one of whether to put text in one format or in another. It was simply whether the text should be within one box of the plan or another box of the plan. And it was an issue which, in fairness, we did try to agree privately, but we couldn't. And it was an issue which the tribunal found incredibly frustrating to have to deal with. And had we had more time, perhaps we should have pressed the opposition harder on that, just to try and make it go away. because that was the sort of issue which the tribunal was very unimpressed to have to deal with, an expert tribunal with such an issue. So be proactive in trying to deal with things like that. Ask for breaks. I know that these hearings are very tiring, and I know that they can, before you know it, just go in the blink of an eye if you're not careful. And so you need to be very cognizant that you and your team will fatigue over time. So be proactive about that. Be polite about things, but when there's an appropriate time to do so, interrupt the proceedings to ask if a break can be had. And the judge will be very receptive to that. And indeed, encourage members of your team to themselves ask for a break, or to communicate that through their advocate, just to make sure that everyone feels comfortable, everyone's performing well, and that's absolutely key. Penultimate bullet: no matter how much you prepare, there's going to be unexpected things that happen during a hearing, technical issues, interruptions, and indeed just unexpected fatigue, and you're going to have to become flexible in dealing with that, and the way to deal with that is to be proactive. When issues emerge, raise them with the judge. Explain that, for example, a witness has mentioned that suddenly there's a child caring issue that they need to deal with. Can you have a brief adjournment so that can be addressed? I've had a case where an expert panel member had a delivery to their door, and they shot off of the screen in order to take that delivery. And so these are issues which are unique to remote hearings, and they're unexpected, they're going to happen, and you're just going to have to deal with it as best as you can. Importantly, if you do miss an exchange over the hearing of evidence or submissions, it's not inappropriate to ask for it to be repeated. I've had to do that a couple of times, and I feel that it's my responsibility as an advocate to make sure that I'm aware of everything that happens in the hearing so that my client is best represented. So if you have to, you ask for evidence to be repeated. Right, my final top tip is in relation to the working document. So if you've got an appeal in respect of the contents of a working document, we'll all know that the document will likely evolve during the course of the hearing, because the tribunal will deal with issues. It will say, all right, heard your position on this, I've heard your position on that. So what if the plan said X instead of saying Y? And then X will deal with both of your positions, and then the judge will say, so can I confirm that you're content with X being shown in the plan? Now, the way that sort of iterative approach to conducting these cases would work in the good old days pre-COVID is that you might have a master plan. So you might have a master document which you and your opponent will agree, this is the one that we're going to record the evolution of the plan within. But you can't do that, of course, in a remote hearings context. So that means you've got to keep a really good record of what's changing in the plan as you go along. And what I suggest is a number of tips around this. So firstly, keep your own private record of the document and record within it the changes that are made, or if you feel more comfortable, record them within a separate note of what's changing. So page 4, OT direct intervention changes from 10 hours a week to 12 hours a week, and keep a record like that. Other top tips are that it, it can be appropriate and sensible where there's a lot of changes to a working document to actually circulate to the tribunal and the participants an updated working document during the hearing. I've had this a couple of times where there's been a lot of changes to the plan, and it would be helpful to everyone to see the plan as it has evolved during the hearing in order to deal with submissions or to deal with other issues. And so for that reason, I've suggested it in the past that, that the plan is circulated to everyone in order to allow that. And so that's something that I suggest. Another good tip is when it comes to some textual changes, we'll all know how detailed textual changes might have to be when it comes to matters in dispute, and every word can count. And when it comes to trying to reach agreement on new wording in the plan, or to discuss amended wording and the significance of that, one approach is to read it out. So I might say, while cross-examining an occupational therapist, okay, Ms. So-and-so, well, what if the plan said this, X, Y, Z? Doesn't that satisfy your concerns? Now, that's one way of doing it. But the trouble is, what X, Y, and Z entail might be quite complicated and lengthy. And so one way that I've got around doing this is I have, before asking the question to the OT in cross-examination or making the submission or whatever, I've written the text that I want to discuss within the chat box of the software so that everyone sees it, it's circulated to everyone, and then we can work off of that text that everyone sees, and it's much easier to analyze and process the information if it's recorded in that way, rather than a case of having to say it out loud and for people to verbally or auditorily, sorry, process that and try and remember what it is that you're saying. So those are my top tips on the working document. Keep a clear, keep your own copy. Be absolutely meticulous in recording all the changes. Send an updated working document during the hearing. Perhaps offer to send one after the hearing as well, so that the judge and the panel member can look at that when they're performing their deliberations, and also use the chat box. So thank you very much, everyone, for listening to my presentation and Michael's presentation earlier. And sorry again that he couldn't make it due to his attendance at the court hearing. I don't believe we've had any questions, which could mean that I have answered all the possible points that might occur to you. And I hope that's indeed the case. I'll just wait a couple of seconds now just to offer a final opportunity for anyone to ask any questions if they want to do so. And while I'm doing so, I'll just repeat that, repeat the point that at FTB, we're very open for you to reach out to us privately and to get in touch with us if you've got any questions. And possibly Deirdre could circulate my email address in due course so that you can get that. So if you do have any questions that you want to ask, not in this small public forum, then you're very welcome to reach out to me, and I'll do my best to answer that. But we've got one question. So thank you, Rachel. So Rachel asked a very important practical question, which is in relation to the email address for a working document during the hearing. And Rachel, what I've done is a twofold approach. There's the usual sendist email address, which is the generic one that you use for circulating and serving and lodging bundles and communicating with the tribunal. So I use that. I also ask the judge if they'll kindly share their direct and personal email address as well. And I found that the judges are open to that, just so that the document arrives at them very fast, and then the judge can forward that on to the panel member. And really, really, sort of the key point that underpins all the top tips that I've delivered today is to be proactive about this, because I think the tribunal responds so well when they see attempts to conduct these hearings in the most appropriate and sensible way, and that they will be flexible to do that. So that's the only question. It was a very easy one, but thank you very much for that, Rachel. Thank you very much, everyone, for joining. I'll just say again just how grateful I am that you all attended for this FTB webinar. I hope to hear from you all shortly. Either you'll be joining other webinars in the autumn, or indeed we might come across one another in a more formal context in the case of a hearing. I hope you all have a lovely summer. You've all deserved it, because I know how hard our professions have had to work over the last few months. Thank you very much, everyone.